So going through those benefits, let's talk a little bit about, well, there's obviously still room for dispute, and there's a lot of disputes that do come up. Just kind of a quick run through of the basic understanding of how the litigation system works. How do we go about resolving disputes between the employee, the employer, and their work comp insurance company? And really who oversees the first stage of it and really kind of clears most of these claims, and most of the disputes are resolved at the government agency level. So as I mentioned before, the Wisconsin Department of Workforce Development is the government agency. It's part of the executive branch. The Workers' Compensation Division handles this. They're a state government agency who has been given the task of enforcing the law and resolving disputes on specific claims. Their decisions have the force of law, meaning that the employer has to comply with it, has to comply with the orders, just like a judge that sits in a courthouse, like we traditionally think of judges. Those judges are circuit court judges and part of the judicial branch of the government. This is the executive branch, part of the government agency, but they have the same force of law. Typically, what's very common among these disputes is that there's independent medical exams, as I mentioned before, called IMEs, where insurance company hires a doctor to review the treatment, maybe and probably also inspect the person themselves and examine them and look at the treatment to determine what's reasonable, what's not. And usually the dispute resolution process starts out with the employee, usually through an attorney, filing a hearing application, what's called a WKC-7. And if there's an unresolved dispute, that's where they file it. That's what they file with the Department of Workforce Development, and that starts the litigation process. And first question is, how does the employee's attorney get paid? Well, if there's a disputed amount, whether it's TTD, PPD, any of the above, or maybe the entire claim, then the employee's attorney is limited to 20% of the amounts that are in dispute. That's the maximum they can get. Generally speaking, that's what they'll get. So they can't make up their own rules. They have to comply with what the state statutes say and what the Department of Workforce Development has promulgated as rules. That's how those attorneys get paid. If it turns out that the employee gets an attorney and there's really nothing in dispute, the attorney still gets a little something, but it's maxed out at 10% or $250. Sometimes it's good just to have it checked over, but they're not going to get much for that, and the attorney's not going to get much for that. And in cases where there's permanent total disability, the most that employee's attorney was going to get is going to get maxed out 20% of the first 500 weeks. So it's not a huge number for the rest of their lives. The attorney's fees are definitely capped out. So you've got a dispute with the employee files a dispute, and the insurance company hires defense counsel. What does that litigation process look like? Unresolved disputes are heard in front of an ALJ, administrative law judge. The administrative law judge is the fact finder, assesses credibility of any testifying witnesses, and makes a ruling. And that's the start of the process. And these kind of hearings are very different than what we see in civil court. If you go to circuit court in Waukesha County, Milwaukee County, or any county in front of a judge, it's very, very different. Those circuit court judges are elected in our state. Administrative law judges are appointed by the governor. That's how they get their jobs. That's how they get there. And again, it's unlike being in civil court. There's no jury. You don't sit in front of a jury to decide, make decisions of fact. That's what the ALJ does. There's rarely ever any pre-hearing depositions. If you're in a car accident where you're suing somebody, there's probably several depositions that go on between the employees, or between the people involved, before you ever get anywhere near a trial. Completely different in workers' comp. There are very, very rare exceptions where you'll have a deposition, and it's usually because there's going to be a witness who's going to be unavailable later for whatever reason. Very limited discovery. When we say discovery, if you're ever in civil court, you've ever been through a lawsuit, there's a lot of what's called written discovery that goes back and forth, production of documents and questions and interrogatories, and it is a long, long process. None of that happens in workers' comp. About the only thing that really happens is medical records and reports are obtained by the parties. doctors complete reports rather than testifying in person, because that's an efficiency thing. They put it all into a report that's given to the administrative law judge rather than have the doctor come and testify in all these cases. It's all done in writing. Typically, the only people we see that show up for testimony in front of the judge is the employee themselves, not surprising, and any fact witnesses that are important. That's usually coworkers, people who may have witnessed an accident. If there's a dispute about basic compensability, those are the people that actually show up, none of the others. And really, the only issues that get brought up in front of these hearings are disputed issues. Again, very different than civil court. Civil court, you have to prove every aspect of your case. Even if it's pretty clear cut, you have to go through and prove every element. In a work comp hearing, you're only arguing about what's disputed. I mean, you could have paid all kinds of temporary total disability, all kinds of medical bills as the insurance company. Everybody agrees what's owed, that's all paid. The only thing that you're going to litigation on is maybe what the correct permanent partial disability is, or vocational rehab, or is this person really a perm total or not? Those all come into play. So you only go over what's actually being disputed. And one of the great questions, and it didn't matter what state you're in, I've talked to defense counsel, and there's always a question that comes up from the employers and everything else. Are we going to win at the hearing? And every defense attorney says the same thing. Well, it depends on which ALJ we get. And once we get the ALJ assigned, I'll tell you what our chances are. And that is, I've heard that over and over again, various jurisdictions, various defense attorneys, because like everybody else, administrative law judges have biases one way or the other. They tend to side more with employers than employees, although I'll say probably more employee leaning more than employer leaning, but they all have their own personalities, and that really plays into a lot of these things. And are we going to win at hearing? Well, we'll let you know which ALJ we're going to get. I'll tell you, I have a pretty good idea at that point what's going to happen. It's usually what we hear. Now, the overall litigation process, first of all, we've talked about it. The administrative law judge is the first. If you don't settle the claim before it goes to hearing, well, then the administrative law judge runs the hearing. They go through fact finding, makes a ruling. And if one of the parties disputes that, doesn't like what it has, that party, whether it's employer or employer, can file an appeal to what's called LIRC, which is the Labor and Industry Review Commission. And that's a government agency that sits over the Department of Workforce Development and reviews decisions of the administrative law judge, not only in workers' comp, but also in unemployment and under employment discrimination claims. But in what we're talking about here today is they review the work comp decisions of the ALJs. So there's a chance to review that. Now, if they make a decision, then one of the other, both either the employee or the employer have the right, once they exhaust all their remedies inside the agency, can then file a lawsuit in circuit court, which is now we're in the judicial branch. We're now in the court system of the state of Wisconsin. And it gets filed in the circuit court, typically of the county where the incident happened. And the circuit court judge, your local judge, will make a decision. Now, as a practical matter, most of these cases, most of the circuit court rulings tend to simply agree with whatever LIRC had made the decision. And it's really kind of a pass-through. Practically speaking, it's become a pass-through, and then it goes on to the Court of Appeals. But what's interesting is there was a big change in 2018 about the question is what deference does the judicial branch give to the agency's interpretation of the law? And the reason is because, agencies are supposed to be specialists in the areas that they're supposed to be working in. And here we're talking about workers' comp. And for decades, the Wisconsin court system has given what's called great weight and deference to the agency's interpretation of the law. There's a little nuance to that, but understand what that really means is if the agency's interpretation of the law is reasonable or plausible, is probably, I think is the word that we often use for that, is a plausible interpretation, then the courts tend to side with that. So the agency has a lot of sway in how the law is interpreted. And that's what the law has been now for a long time. But in 2018, the Wisconsin Supreme Court has specifically thrown that out and said, we're not going to follow that anymore. This is actually a really, really big decision that's going to it's going to have to be dealt with a little while, for a long time, but it's a big decision because now the the deference that judicial branch gives to the agency is now what we call due weight and deference. Now, what's the difference between great weight and deference versus due weight? Well, the court can now is much freer to say, you know what, even though the agency's decision is plausible, or within the realm of plausible, we do not have to agree with that. We think that there's a superior interpretation, and we're going to overrule the agency. Now the courts in Wisconsin can do that, and we're going to see how that plays out. It's going to be really interesting how that plays out. So it's kind of an important thing to understand. You may see some changes where maybe we haven't seen before. Again, wait and see. But let's say, again, as I said, the circuit court is often just the rubber stamp what LIRC says, and so the parties end up appealing to the Court of Appeals, because they have mandatory jurisdiction. That means if you appeal to the Court of Appeals, they have to take it. They have to take the case, they have to make a ruling on it, and up or down, sideways, whatever they want to do, they have to take the case. And if you don't like what the Court of Appeals says, then you can, if you want to, take it to the Wisconsin Supreme Court. However, the Wisconsin Supreme Court, they have what's called discretionary jurisdiction, which means they do not have to take the case. It's their choice to take it or not take it, and they don't have to give a reason why. And so basically, if the Wisconsin Supreme Court refuses to take the case, then the Court of Appeals case is what stands. They are the last word in Wisconsin on the interpretation of workers' comp because it's a state law issue. Once all these things happen at any level here, the case can then go back down to the Court of Appeals. It could go back down to LIRC. It could go back down to the administrative law judge for further findings of fact, for rulings, etc., that would go into the case. So it could get remanded back down for further handling in compliance with whatever they said. So it could be a long process, and if you're up at the Wisconsin Supreme Court, that is a long, long time from the date of the injury until that happened. So statute of limitations, this is all part of the litigation process for traumatic injuries, which is the vast majority of what we see out there. So prior to March of 2016, March 1st of 2016, on or before, make clarification, on or before March 1st, 2016, it was 12 years. And that's from the date of injury, the date of death, or the date of payment of last compensation. So if you paid somebody temporary total disability 6 years after the date of injury, then that date of that last payment, they have 12 years to continue their case for what it boils down to. That was recently changed on March 2nd to 6 years. So that now there's a much shorter period of time. It's still a pretty long, 6 years is still a pretty long period of time, but it's significantly less than 12 years. So that has recently been changed. So older cases, I do believe the 12 years applies. The newer cases, I think, is going to be now on or after, injuries on or after that March 2nd date are going to be 6 years. There are certain types of traumatic cases where there's no limit, statute of limitations. So if you have an amputation of a hand, arm, leg, foot, or vision, there's no limitation on that. Permanent brain injuries, if there's an artificial spinal disc put in, there's no limitation, statute of limitations on that one. Or if there's a total or partial knee or hip replacement. And that really revolves around the fact that there's an anticipation that there's going to be lifelong medical and potentially future surgeries involved, and so they don't want to put a statute of limitations on those. Interestingly enough, Minnesota, for example, has no statute of limitations on medical treatment. So there's no statute of limitations at all in Minnesota, really, for these kind of injuries. Wisconsin does put a limitation on them. Occupational diseases, and I'm going to talk about occupational here coming up shortly, is still 12 years, not 6 years. It's still 12 years in the state of